A case involving a letter sent by a prison inmate is in front of the South Dakota Supreme Court.
Much of the arguments presented to the state's high court today revolved around a couple of words and how they should be interpreted. KELOLAND's Kelly Volk explains.
While in prison, Joshua Armstrong sent an envelope to the Compass Center. The envelope was addressed to PREA, or Prison Rape Elimination Act. That means staff at the prison could not review what was inside the envelope before sending it. Inside the packet were letters to PREA and then Governor Dennis Daugaard. In that PREA letter, Armstrong wrote about contemplating raping and killing a mental health therapist who is being called CH in this story. Armstrong was indicted on one count of threatening to commit a sexual offense, which means he's alleged to have directly threatened or communicated the specific intent to commit further felony sex offenses. Armstrong pleaded not guilty, arguing the state didn't provide sufficient evidence that he directly threatened CH. He asked for an acquittal, but it was denied. He also requested 2 jury instructions. One of them was that to find him guilty, the jury must determine beyond a reasonable doubt that he directly threatened or directly communicated specific intent to commit a further felony sex offense. His instructions were denied, and he was found guilty.
We would argue that that is
today, an attorney for Armstrong presented this question to the court.
What is the meaning of the term directly within this statute? And does that term modify both the word threatens and the word communicates within that statute?
But the state highlighted a 2-letter word in the statute.
They are separated by the word or. Or is usually used in the disjunctive, meaning a choice between 2 mutually exclusive things. You either directly threaten or you communicate specific intent. It's an either-or situation. And we have that. The state proved that.
The South Dakota Supreme Court will make a ruling at a later date. Kelly Volk, KELOLAND News.
You can read part of that letter on KELOLAND.com.